Welcome to another installment of Rochelle's Daily Wire Video Edition. I am Bill Rochelle, Editor-at-Large of American Bankruptcy Institute. Today we're going to talk about the concept of impairment in Chapter 11 reorganization cases, and in particular, a decision from the Fifth Circuit called Ultra Petroleum. Impairment is, of course, significant in Chapter 11 because a creditor cannot vote on the plan if the creditor's claim is unimpaired. Therefore, it's important to know whether or not a creditor is impaired. Take this circumstance, for instance. Assume that you have a landlord with a rejected executory or an expired lease. And let's say that that landlord has a claim for 10 years of future rent, which would be absolutely valid under state law. Under bankruptcy code, of course, that claim is going to be cut back very substantially, maybe down to a couple of years of future rent, or less perhaps. Question is, because the bankruptcy code caps and cuts down that claim, is the creditor impaired or not? In his decision for the Fifth Circuit, newly appointed Circuit Judge Oldham tells us that no, that creditor is not impaired if it is the bankruptcy code that cuts down on the claim. He tells us that a creditor is impaired only if the plan itself, the Chapter 11 plan, cuts down on the claim. This case, Ultra Petroleum, actually could be even more significant in the future because it's going back to bankruptcy Judge Marvin Isker in Houston on remand. The reason it could be important in the future is that Judge Isker, I believe, is now going to have to deal with the question of make-wholes and whether make-wholes are allowable claims in Chapter 11. On that issue, we already have a circuit split. The Second Circuit has told us that make-wholes are not allowed in bankruptcy, while the Third Circuit has taken the opposite position and has said and held that make-wholes are very much allowable in Chapter 11. Make-whole, by the way, arises under a bond indenture where there will be a provision providing that the holders of the bonds can have an additional premium, some people think it's a penalty, arising because the bonds were paid prior to maturity and the investors were forced to reinvest at a lower interest rate. In any event, after this case goes back on remand and comes back to the Fifth Circuit, the Fifth Circuit may very well have to take a position on that circuit split and rule whether or not, in their view, make-wholes are allowable in Chapter 11 cases. One way or the other, whichever the way the Fifth Circuit rules, there will be a split of circuits. And I should hope it would be a very nice issue for the Supreme Court to take on and resolve that split of circuits. Well, until then, this is Bill Rochelle, and we will be back same time next week to discuss another important issue of bankruptcy law. If you want to read more about the Ultra Petroleum case, visit my column on the ABI website for January 23. In the meantime, be well, don't work too hard, and we'll see you again next week.